I've worked as a cleaner in the Monroe County Courthouse for 20 years. I started at 20 because I needed any job I could get. I dropped out of high school at 16, had no diploma and no specialized skills, just a strong back and a willingness to work. The courthouse hired me to clean bathrooms, mop floors, and empty trash cans in rooms where attorneys argued cases I didn't understand. I assumed that would be my entire career, but 2 decades of listening changes a person. Now I'm 40, and I'm no longer just a janitor. I'm a law student. I began night classes 2 years ago, starting at community college and then transferring to the state university on a full scholarship based on age and income. 4 nights a week after my shift, I sit in classrooms studying torts, contracts, and constitutional law. During the day, I review real cases happening in the same courthouse I clean. I know every judge, every lawyer, and every courtroom, even if they don't know me. But on one October morning, that familiarity ended up helping someone. Maybe not saving her life, but certainly preserving her financial future. For Marianne Bogart, that mattered just as much. Have you ever been underestimated because of your job? Share your experience in the comments. And if you like stories about underdogs, second chances, and proving assumptions wrong, consider subscribing and turning on notifications for more. That day, I was cleaning the hallway outside courtroom 3B. Inside, Bogart Z. Hawkins was underway, a high-profile divorce case attracting plenty of attention. Marianne Bogart, a fashion mogul who built her brand from the ground up, owned a company worth nearly $1 billion. Her ex-husband, Christian Hawkins, wanted half. They had a decade-long marriage, and he had contributed, based on the filings, mostly his charm and social presence, rather than money or business expertise. Still, in a community property-style state, he believed he had a claim. But Marianne had a solid prenup. Christian was entitled to $5 million, which was generous but far less than half. He argued the prenup was signed under pressure and that she hid assets. His attorney was aggressive and expensive. Marianne's lawyer, Adam Hart, had a strong reputation, and I'd seen him around for days. Polished suit, confident stride, clearly someone skilled. Yet something felt off that morning. As I wiped down a water fountain, I heard raised voices. Judge Goodwin sounded irritated, questioning Hart's sudden statement. Hart said he'd received a message that morning and could no longer represent Marianne. Silence followed. Then he announced he was withdrawing immediately due to a conflict of interest. The judge pushed back, noting the trial was already underway, but Hart insisted and left quickly. Surprised, I opened the courtroom door slightly. Marianne sat alone at the defense table, pale and shocked. Judge Goodwin asked if she knew this would happen. She explained she'd only received a brief text minutes earlier mentioning a conflict, even though they'd worked together for months. Christian sat smirking, while his attorney, Gerald Vance, whispered to him. The judge declared a recess until 1 p.m., giving Marianne time to secure new representation. Otherwise, the trial would continue without counsel. Marianne looked devastated. I closed the door and returned to my cart, but something felt wrong. Adam Hart wasn't the type to quit mid-trial without warning. I suspected Christian had influenced him, whether through pressure or incentive, I couldn't prove, but my instincts were strong. During a break in the janitor's closet, I ate a sandwich when my phone buzzed. My professor, Jonathan Olson, had texted about lunch at our usual spot. Jonathan teaches my constitutional law class, but he's also become a mentor. He's 70, retired from active practice, but still committed to teaching. We meet weekly to discuss cases and theories, and he always treats me as a peer rather than the janitor who goes to law school. I texted back that I couldn't meet and asked if I could call. When we spoke, I explained the situation. The high-stakes divorce, the lawyer quitting, my suspicion about the husband's involvement, and the fact that Marianne had almost no chance of finding competent representation within an hour and a half. Jonathan paused, then asked what I was thinking. I said I knew the case inside and out. I'd read every motion and filing. I told him I wanted to represent her. He reminded me I was a second-year student with no courtroom experience, facing a seasoned attorney. I understood, but insisted she had no one else, and that I could do it under supervision. Under the student practice rule, I could appear in court if a licensed attorney oversaw me. I asked him to supervise, not to argue, just to sign off and be present. After a long pause, he agreed and asked where I was. Third floor of the courthouse. I said. He told me he'd be there in 20 minutes. I went to find Marianne, who was seated in a hallway making call after call, receiving one rejection after another from attorneys unable to step in on such short notice. When Professor Olson arrived, moving steadily with his cane, but full of purpose, we met at the entrance. He asked if I understood the responsibility and warned that opposing counsel would not ease up simply because I was a student. He reminded me that any mistake would cost Marianne dearly. I told him I'd fix any errors I made, and he gave a small, proud smile. He agreed to supervise but made it clear all the work would be mine. It was already 1, so we hurried to the courtroom. When the judge asked if Marianne had found representation, she said she hadn't. I stepped forward and stated that I could represent her. The courtroom reacted instantly. Christian's attorney stood, arguing that I was just a janitor. The judge told him to sit. The judge then asked Marianne if she understood. She said that if I was qualified, she'd accept, since she had no other options. The judge asked my name, and I introduced myself as Daniel Murray, a second-year law student. He looked at Professor Olson, who confirmed he was licensed, knew the case, and would supervise me under the student practice rule. The judge appeared skeptical but curious. He emphasized the complexity and high stakes of the case and asked if I felt prepared. I said I did. He warned he would hold me to the same standards as any attorney. I agreed. The judge allowed the case to proceed. Gerald Vance rose, still confident, and called the next witness, Christian Hawkins. My stomach dropped. My first courtroom task would be cross-examining the plaintiff himself, the man at the center of the entire case. It was an intense moment, but there was no turning back. Christian Hawkins took the stand, appearing confident, well-dressed, and composed, smiling at the jury as if the outcome already favored him. Gerald began with easy questions. How long he had been married to Marianne, what role he played in her business, and whether he contributed financially. Christian claimed he supported her socially and emotionally, represented the brand at events, and maintained the household so she could focus on work. When asked about the prenup, he testified that he didn't fully understand it and said Marianne pressured him into signing, claiming he felt he had no choice. When Gerald asked if he felt coerced, I objected for leading, and the judge sustained. After rephrasing, Christian stated he felt rushed and lacked independent legal review before signing. With no further questions, the judge turned to me. I approached, reviewed my notes, and asked whether he truly had no lawyer at the signing. Christian admitted a lawyer was present, provided by Marianne, but claimed he didn't recall asking questions. I pressed about whether he read the document, and he said he only skimmed it. I then questioned his claim that he managed the household. Breaking down the details, the staff hired, paid, or supervised, and he admitted he did none of those tasks. When I asked for examples of him helping Marianne network, he offered none. I confirmed he had no employment during the marriage, earned no salary, contributed no income, made no investments, and held no assets that went into the marriage. When he said he contributed support, I noted that the prenup compensated him with $5 million. He also claimed Marianne hid assets through offshore accounts, but admitted he had no proof, no documents, and no direct access to financial records. When I asked if he made these allegations simply because he disliked the prenup he signed voluntarily, the judge allowed it, and Christian repeated he acted under duress, though he had been in a lawyer's office and could have declined to sign. I concluded the cross-examination and returned to my seat, relieved to have managed my first one effectively. The judge called a brief recess, and in the hallway, Professor Olson complimented my calm and methodical approach. Marianne also expressed appreciation, noting it was the first time in days she felt someone was advocating for her. When the session resumed, Gerald called his next witness, Sandra Kemp, a woman in her 50s who had served as Christian's assistant during the marriage. She described her administrative duties, including managing his schedule and handling some paperwork. When Gerald asked about financial documents, I objected to vague wording, and the judge sustained it. After rephrasing, she claimed she had seen offshore account statements from multiple countries, suggesting undisclosed funds. This was potentially damaging, so I challenged the foundation of her statements, and once sustained, continued questioning. Sandra admitted she had not verified the authenticity of the documents, had not contacted any banks, had no access to Marianne's actual financial records, and simply viewed files on Christian's computer. I asked if she understood the documents well enough given her background, and whether she knew such files could be fabricated, and she acknowledged the possibility. When I asked her salary and where it came from, she reluctantly admitted she was effectively paid from household funds that Marianne provided, meaning she was paid by the same woman she now testified against. I questioned whether she was stating facts or repeating what Christian wanted her to say. Though objection was raised, I withdrew it and ended my cross. Sandra left the stand clearly unsettled, and Gerald appeared less certain. Gerald then called his final witness, Dr. Kenneth Marsh, a seasoned forensic accountant with decades of experience. Dr. Marsh testified that Christian hired him to review Marianne's finances and that he found signs of offshore accounts, foreign trusts, and shell corporations that suggested concealed assets. He estimated the hidden value at $200 million. Marianne whispered that the claims were false, and I assured her we needed to address them carefully. I began my questioning by establishing Dr. Marsh's credentials and experience, then asked about the evidence he relied upon. He listed bank statements, wire records, and filings, all provided solely by Christian. I pressed him on whether he had independently verified any of these documents or authenticated them through direct contact with financial institutions or through official channels. He stated only that he reviewed them for authenticity, which implied he had not personally confirmed their validity. I continued to focus on the reliability of the materials and the fact that every item originated from Christian rather than from any neutral or verified source. I asked Dr. Marsh whether he contacted the banks directly, and he said that wasn't standard practice, meaning he relied entirely on the documents Christian provided. When I asked if those documents could be fabricated, he said he checked for signs, a forgery, and they appeared genuine. I noted he hadn't verified them, prompting an objection that the judge sustained. Shifting direction, I asked if he was familiar with Marianne's company, Bogart Couture, and he confirmed it was publicly traded, meaning its financials were accessible through SEC filings, annual reports, and audits. When I asked whether he reviewed those records, he said he had looked at some but found no discrepancies, even when asked directly if he uncovered anything suggesting hidden assets. He argued public documents wouldn't show concealed money, but they would reveal inconsistencies if $200 million were missing. He conceded that he saw no issues in Bogart Couture's filings. I then asked about Marianne's tax returns. He said he requested them, but her legal team didn't provide them. Marianne whispered that she had copies with her, so she handed them to me. I approached the witness with the audited returns covering 10 years. After reviewing them silently, Marsh admitted they looked standard and contained no evidence of offshore accounts or shell companies. I pointed out the IRS had reviewed these returns for a decade and didn't find the issues he claimed, based solely on documents from a man with a financial motive. The judge sustained the objection, but the jury already seemed doubtful. With no further questions, Gerald rested and the judge turned to me. I called Marianne to the stand, calm and composed. She answered questions about her business, marriage, and the prenup. She denied having offshore accounts or hidden assets, stating Christian fabricated documents because he was frustrated that the prenup limited him to $5 million. When asked if she could prove her honesty, she said she brought her accountant. The accountant testified thoroughly for half an hour, outlining every asset and confirming nothing was hidden. Gerald's cross-examination didn't shake her credibility. During closing arguments, Gerald claimed Christian was coerced into signing the prenup and that Marianne concealed assets to avoid paying him. When it was my turn, I told the jury that the case was indeed simple, but not for the reasons Gerald stated. I explained that Christian lived off Marianne's success for a decade and now wanted more than the agreement he signed. The prenup was a contract he reviewed in a lawyer's office, could have negotiated, and could have refused. His claims of hidden money were unsupported. The evidence rested on fabricated documents, an expert who didn't verify them, and 10 years of audits showing no inconsistencies. I reminded them that stories aren't evidence and all verified records supported Marianne. I ended by stating Christian was the one trying to game the system, and they had the power to prevent that. The courtroom went silent before Judge Goodwin instructed the jury to deliberate. The next morning, the jury returned, sitting beside Marianne and with Professor Olson behind us. I tried to steady my shaking hands. The judge asked if a verdict had been reached. The foreman read the decision. The jury found in favor of Marianne, upholding the prenup and rejecting all claims of hidden assets. Marianne squeezed my hand as I exhaled, realizing how tense I had been. The judge confirmed Christian was entitled only to the $5 million stated in the agreement. Christian stormed out while Gerald packed quietly. Marianne, emotional, told me we did it, and Professor Olson congratulated me on the work. A week later, while I was mopping the courthouse floors, I received a call from Marianne. She thanked me again and insisted on giving me the $50,000 her former lawyer would have earned, calling it a gift to support my education. I initially refused, but she insisted. Then she made an offer. Once I finished school and passed the bar, she wanted to hire me as her corporate attorney. Shocked, I reminded her I had no experience, but she pointed out I had performed well against an experienced lawyer. She asked me to consider the offer and encouraged me to keep working hard, but not to stay a janitor forever. After the call ended, I stood in the courthouse I had cleaned for 20 years and, for the first time, believed I was meant for something more. 2 years later, I graduated in the top 10% of my class, passed the bar on my first attempt, and Marianne kept her promise by hiring me as corporate counsel for Bogart Couture. Now I work on the 23rd floor with windows overlooking the city. Sometimes I look down at the courthouse I cleaned for 2 decades and think about the kid who dropped out of high school, the janitor who studied law at night, and the student who stayed when everyone else walked away. Have you ever been underestimated because of your job? Which moment impacted you most? When Dan offered to help Marianne? When he cross-examined Christian? When the jury delivered the verdict? Or when Marianne offered him a job? Share your experiences and underdog stories in the comments. If this story about perseverance and defying expectations resonated with you, please like and subscribe for more stories about second chances and rising above circumstances. Don't forget to turn on notifications so you never miss the next one. Thanks for watching.